Aloha! Meet Daryl IGAWA. He works as a cook at the KOA house restaurant in Hawaii. In 1991, while working in the kitchen, a big soup pot fell 2 feet onto his head. He did not lose consciousness, but he was dazed. After a short recovery, he went back to work. In the following weeks to come, he experienced blackouts, headaches, and nausea. He sought medical attention from Dr. Hosobuchi, who in 1993 diagnosed him with having a cyst on his right frontal lobe, which is a section of his brain. He says that surgically removing the cyst will solve all his problems. IGAWA's employer, for some reason, refused to allow him to go through with the surgery. IGAWA then went to the Labor and Industrial Relations Appeal Board. The board takes into account the report provided by Dr. Nicholson, which states that IGAWA had previously sustained a serious work injury in 1975 and is the original cause of his symptoms. But there is not enough evidence to support the claim that it has nothing to do with his 1991 injury. The board states,
Upon review of the entire matter, it is determined that the surgical excision of the lesion from the right frontal lobe appears to be reasonable and necessary medical care which relates to said work injury. There was insufficient medical evidence to rebut Dr. Hosobuchi's opinions. The medical evidence indicated that claimant's headaches and seizures began after the work injury of 1991, and although claimant had suffered headaches related to the 1975 injury, the condition had been resolved prior to the work injury of 1991.
The board then ordered the employer to pay for medical care, services, and supplies necessary to treat the injury, including the surgery recommended by Dr. Hosobuchi. After being deformed by the surgery, IGAWA was entitled to disability benefits that amounted to tens of thousands of dollars. The employer appealed the decision. He claims that IGAWA's condition was worsened in part by the injury of 1975. Therefore, it was not fair that the amount needed to be paid to IGAWA be based solely on his work injury of 1991. The case was taken up with the Intermediate Court of Appeals. What followed was a long string of appeals and rebuttals by several doctors, insurance carriers, and all parties involved. Many case laws and legislations were brought up by the employer's legal team to dispute the claim by the board. The Intermediate Court of Appeals stepped in and called upon a case law which experienced similar circumstances. The court states,
There was conflicting medical testimony regarding whether claimant's condition was caused by the work injury or was solely the result of the 1975 injury, and that, in instances where the testimony of two doctors directly conflict on the issue of an injury's causal connection to the claimant's employment activity, the conflict should be resolved in the claimant's favor.
So in the end, IGAWA was awarded with a more than significant amount in disability benefits and lived happily ever after. The end.
In summary, KOA House Restaurant owed a duty of care to its employees to provide a safe work environment and to cover most forms of work-related injuries. The remedies of such contract appear in the form of disability benefits paid to IGAWA as compensation for his injuries. Having a dangerous standard operating procedure, i.e. keeping a big soup pot on a high shelf, can be seen as an act of negligence on the part of KOA House Restaurant, and therefore the employers can be held liable for any injury. As a lesson, covering worker injuries should be seen as part of the cost of running a restaurant.